Adoption is never an easy decision. It can be a matter of emotion, it can be a matter of business. I'm Dan Ringer, and we'll talk about adoption right now on The Law Works.
From West Virginia Public Broadcasting.
The Law Works is made possible by the generous support of the West Virginia State Bar, the Monongalia County Bar Association, and by a major grant from the West Virginia Bar Foundation, promoting public knowledge of the law in West Virginia. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system.
Adoption is not an easy matter, and in some instances may not even be possible. My guest is attorney Mark Gatos. Mark, thank you for being with us.
Thank you, Dan.
When we talk about adoption, everybody sitting at home believes they know what adoption is. What technically is it?
Well, basically, it starts out with the proposition that parental rights need to be terminated in one respect or another, and parental rights for the adopting parents have to be reinstituted or recreated. And after those two things occur and the court determines that that happening is in the best interest of the children, then we have an adoption.
I'm always fascinated by the term parental rights because it's not just rights, it's duties and responsibilities, obligations.
It definitely is. And as a matter of fact, one of the things that enters into adoptions at times is whether or not a person has exercised their duties and or obligations with regard to the child.
So going back to what you said originally, a child has what we refer to these days as birth parents. There's a mother and there's a father, and those people have certain rights with regard to the child, but certain obligations with regard to the child.
Absolutely right.
And then we want to end those rights and obligations and create new rights and obligations in one or two other people.
Correct. A normal situation that comes up quite frequently would be the instance where a mother and father have divorced. The father is under an obligation to pay child support and has a right to visitation or co-parenting and is not exercising either of those. The birth mother remarries and her husband is interested in adopting the child and practically has raised the child as his own during the time that the two were married. The birth father or the natural father must be notified of this desire to adopt and must either consent to it or, in the event that he doesn't consent, he advises the court, and then the procedure is one of a contested divorce where you go forward
contested
from there.
Adoption.
Contested adoption, yes, sir.
Okay, let's back up. In general aspect, who's allowed to adopt a child?
Any person over the age of 18 who is at least 15 years older than the child, who has good standing in the community. A person can be single, they can be husband and wife, they can be one spouse with the permission of the other spouse, and essentially anyone in good standing that desires to adopt can qualify to adopt.
Now, the 15-year-old age difference is not an absolute criteria, but it's something that will be looked at very closely.
That's correct, and the court can make a specific determination that despite the difference in age not being met under the code, as long as the best interests of the child being adopted are still met by this adoption, with that specific finding, they can still go through with the adoption.
Okay, the circumstance that I can think of just off the top of my head might be that a married couple has a child, they are killed in some sort of accident, and the younger brother or sister of one of them might come in and say, okay, I'm 14 years older than the child, but I want to adopt the child, take that responsibility on. The court would look at that and make sure that the circumstances were pure in intent and that the adopting parent really was in a situation to make that work and would likely, under those circumstances, approve it.
And that is really the only situation that I've ever come across in my personal practice. A brother who was in college lost both of his parents, and his 12-year-old brother was the subject of the adoption. And he did it for a variety of purposes, but primarily because there was not much of a family element left after the death of the parents, and he certainly didn't want to see his brother go on to some other care facility in the meantime.
Well, who's eligible to be adopted?
Any child, and frankly an adult, who is in a position or desired to be adopted by qualifying individuals.
Is it up to the child?
It is not up to the child, but for instance, in the event that a child is over the age of 12, the court actually brings that child up and the child must consent in front of the court, age 12 or older.
Age 12 is kind of a magic number in a courtroom, and it occurs in a number of circumstances. It's actually a range of ages 12 to 14 that lawyers and courts are most concerned about, and 12 is kind of the threshold age. But if a child is reasonably intelligent and reasonably articulate at about the age of 12, their interests, their desires become important. And it's kind of because a court looks at a child and says, well, you're going to be a teenager real soon, or you are a teenager now, and we're not going to be able to make you do anything you don't want to do.
And it's probably out of deference to the mental health of the parents, too, I would have to say.
Yeah. What's the legal process that one goes through to effect an adoption?
Primarily, you start off with a petition to the court seeking the order of adoption. In that process, upon the filing of the petition, you normally have, prior to that, sought out the other parent, the one that you're seeking consent from, or the one that you intend to argue with, for lack of a better term, at court. You send out the documentation asking for their permission, their consent, and waiver. If you get that back and all is good, then you file your petition. Now, the child, of course, must live with the adopting parent for at least a period of 6 months. And at that point, you file your petition, and as long as the order is entered after the child has been with the adopting parent for 6 months or longer, then you're good to go. The next step in the process is there is a hearing. Now, the judge enters the petition and, depending on the circumstances, may request a home study be done and assigns that task to various groups that do that type of thing, including guardian ad litems, the various state departments. And then that home study is performed, a report is turned over to the court, and then you proceed to hearing. Successful conclusion of the hearing, an order is entered.
One of the nicest proceedings I was ever involved in was an adoption where mom was having her new husband, or the new husband was adopting the mom's child, and at the end of the hearing, the judge said to me, he said, do you have any other questions you want to ask of anybody? And I said, I do. And I turned to the child, who was 3 or 4 years old, and I said, Billy, who's that guy sitting there? And he grinned, he literally says, Daddy. And the judge looked at him and said, you're right. You made it, you made it sound easy without regard to how complex the procedures are that you have to go through, but it's not that easy.
It is not. There are a variety of considerations that go into an adoption, and for instance, in the term of a consent. If the biological father is consenting, that individual has an absolute right to be informed of a particular list of rights that he has. And they include everything from the right to counseling, which must be provided by the department free of charge.
That's the Department of Health and Human Services here
Yes.
in West Virginia.
Absolutely. The right to revoke his consent within a certain time period. The right to consult with a lawyer about these rules and regulations. The right to cover and contest those things which are alleged in the petition. In other words, challenge the rightful adoption of this child by this person because this person is unfit, for instance, or to make an issue of the fact that the petition is faulty and doesn't comply with the statutory provisions under the adoption rules. So many times that decision to consent and waive comes down to one or more of those issues, and then you have a problem. There are other issues, including the unknown father. Obtaining service of process or notice under the statute requires a variety of steps to be taken, kind of too complicated to get into here, but definitely are required.
We're talking about adoption in West Virginia. My guest is attorney Mark Gatos. I'm Dan Ringer, and this is The Law Works. You alluded to something that puts fear into most lawyers, and that's the unknown father. How does it come about that the father's unknown?
By a variety of things, not the least of which is an affidavit that must be signed by the mother. And hopefully you are dealing with a situation where the mother is known. In some instances, the mother has relinquished her parental rights through some type of procedure, proceeding in court, or through an adoption agency.
And sometimes the parental rights are terminated for you. I mean, you may say, I want to be the father, and a judge, upon request of an appropriate authority, says, you're not a fit guy to be the father.
Absolutely, and that oftentimes comes up with abuse and neglect proceedings, criminal behavior toward the child in particular. Those can lead to the termination of parental rights. In that instance, the notice is not required. However, the department or the adoption agency with which the child is placed, foster parents, all of those folks have a right to know about what's going on.
One of the things that I have seen happen is the grandparents or the next door neighbor or the foster parents will come in and say, I've got permission to adopt this child. And you say, well, how did you get that permission? So, well, we went over to mother's house or father's house and had them sign a statement that says, when you look at it, I give permission to John and Mary to adopt Billy or Susie. That do it?
Not by any means. Essentially, I think our courts have universally ruled that that document gives the holder a limited amount of rights to make certain decisions with regard to some school things that they may be able to go through. But as far as it being legal or binding, for instance, in the example you gave me, there is no specific references to when that may be terminated. I'm in the military. I give my mother, because I'm unmarried, I'm a widower, I give my mother control of my children while I'm away. That's fine. That'll cover most bases. It does not establish in her parental rights.
Now, that document we would call a power of attorney, or
Correct.
perhaps a limited power of attorney.
Exactly.
To do certain things, take the child to school, take the child for medical care. And most often, a school or a medical care provider wants to see a document like that.
And especially with the new HIPAA laws and other things, various entities are so scared that they just want something, even though it wouldn't even come close to covering the rule. They just want something in their file to show that they made a good faith attempt.
Yeah, I don't recall what HIPAA literally stands for. It's Health Insurance Portability and Accounting Act.
Yes.
Yeah, that's HIPAA. Yeah, that's what it is. Yes. And it has gotten people so afraid of it, and not really for good reason, but it seems more complex than it really is. But healthcare providers and certain others are so afraid of it that they're almost to the point of not telling you what's wrong with you. And certainly anybody not you, they're going to require a lot of information and a lot of consents and a lot of writings before they'll say anything. So having a properly drafted power of attorney, if you're taking care of your grandchildren or your stepson or stepdaughter or something like that, you really want to talk to an attorney and get a proper piece of paper to authorize you to do those kinds of things. Sometimes we don't know who the father is. Sometimes the father denies he's the father. Sometimes a guy asserts he's the father when he's not. How do we sort all this out?
Well, my philosophy is a little unique in that if I have any inclination that there are, as in the example you gave, the possibility of 3 people with some right, I will notify all 3 individuals that this adoption is being presented to the court. Now, you have the birth father, or as I say, the natural father that was, for instance, the husband at the time of the birth. Paternity may say that's not his child, however, he is on the birth certificate and presumed.
And the law presumes that if a woman conceives a child or has a child while she is married, her husband is the father of that child.
And his name appears on that birth certificate automatically as the father. Time goes on and that changes. It turns out that paternity is attempting to be established by another individual, and mom is attempting to have the child adopted by her second husband, for instance. Again, the second husband is the petitioner, the mother is consenting. The father on the birth certificate, who is not the legal father, well, who is the legal father but not the
birth father
or natural father, and the actual father who is attempting to prove paternity, all have to be notified.
You know, the thought occurs to me, this program is posted to YouTube, and it's being posted to iTunes also as a podcast, and somebody's going to listen to this and they're going to say, yep, they're in West Virginia. Folks, this happens everywhere, where the woman may not know who the father of the child is. Somebody may be claiming to be the father but isn't. Somebody may be denying to be the father but is. It can be very complex and very nasty, and within the legal community it's pretty widely recognized there are a lot of children running around who are not their father's child, even though mom says they are. We're talking about adoption in West Virginia. My guest is attorney Mark Godos. I'm Dan Ringer, and this is The Law Works. Well, if a man is claiming to be the father of the child, that pretty much shuts down the adoption process unless you can either prove he's not or that he shouldn't be.
Yes, it can delay things, and it can shut it down completely, particularly if that individual has gone through the process of acting as the father, holding himself out to be the father, taken certain steps to support the child, or prenatal and postnatal assistance to the mother. Those types of things, which we get into in an abandonment argument, all are good evidence that he has standing to contest this adoption.
Many times I have heard people come in and say, well, the woman typically comes in and says, I want my new husband, or my first husband, if she had a child when she wasn't married, to adopt this child. He wants to adopt this child. We want to be a home. We want to be a family. But my ex-husband, my ex-boyfriend, the child's father, is refusing to give up his rights. He wants to see the child. He's willing to pay child support. I just don't want him in the family. I don't want his nose in my tent. That's not going to be a successful adoption under those circumstances.
No, without more, the courts and the state do not interfere or terminate someone's parental rights simply because mom and dad don't get along.
Even if that's what the child wants, and even if it looks like it would be in the child's best interest.
Correct.
Stepdad is worth $1 gazillion, and the real father is an unemployed bum. And it's not to say you're a bum if you're unemployed. He's unemployed and a bum. So he just is not. It would not be in the child's best interest logically to have that man be the child's father. But the law's going to allow him to be if he wants to be.
If he wants to be, and he has held himself out to be, and taken steps and been involved with that child. Absolutely, he continues on in that capacity.
Well, in preparation for this show, and you mentioned the word abandonment, we need to talk about what constitutes abandonment. I'm not going to give you a test and ask you to name all of the ways that it happens, because there's a fairly long list of it. But in West Virginia, abandonment can be found if one of the parents fails to support the child within that parent's means. What does that mean?
Essentially, if the simplest example would be in a divorce scenario, you have been assigned a certain amount to pay in child support. Obviously, the calculation results in that being your means and ability to pay.
A judge has determined you have the resources to pay that amount.
And that's what you are to be paying. You have been dragged back to court kicking and screaming. You've been thrown in jail several times, and you still refuse to pay your child support. That's what they're talking about. Or you know this is your child and you refuse to acknowledge that child. That's another form of abandonment. And then add to that the financial component that you have the means to support this child and you are providing no assistance to the mother.
Another way to abandon a child is failure to visit or communicate when it's possible to do that. Now, it means if a person's in the military and they're overseas, they can't visit, but they may be able to communicate, and they may try to communicate. And that failure to visit or communicate has to continue for 6 months without interruption. What does without interruption mean?
For instance, if within that 6-month period the child had a birthday, you were away or predisposed in some other capacity to some other event, and you simply sent a card, you phoned, that would interrupt that 6-month cycle. If you have not been heard of, seen, or particularly good evidence of that is you've moved without providing a forwarding address or any further information to be able to contact you, and for 6 months you have had no contact with your child whatsoever, haven't sent your support payment, that can be considered your 6-month period.
Technically, we say that's a presumption of abandonment.
Right.
And then it's possible for the parent to come in and say, well, here's why I couldn't communicate, and that may be forgiven by the judge. Of course, if you're in prison for raping the child's mother and don't communicate because you're in prison, that doesn't count. Logically, it shouldn't, and it doesn't. Another way to abandon is to failure to contribute for prenatal care and birth expenses within your means, and I think you alluded to that.
Right, and these things are to be taken as a whole, in conjunction with one another. The simple non-communication in 6 months, but you are providing care financially or some other form, we don't have abandonment. You have sent cards, pictures, letters, but financially you've had some medical issue or some other things that have come up that have caused you not to be able to send your support, including the fact that you couldn't afford a lawyer to go back to court to get your child support reduced. That's another example. These items that you've listed, and roughly there's 5 or 6, they are looked at together. And that is one of the factors particularly, and that one normally combines with the fact that you do not even identify that child as yours.
If you say that's not my child, that's a big matter in the concept of abandonment. The judge will say, okay, that's really... One of the last criteria for abandonment, or possibilities for abandonment, is the father fails to make reasonable efforts to discover that the woman was pregnant or had a child. And I would refer to that as the case of the unknown child. All of a sudden you get something in the mail that says, we want to adopt your child that you didn't know you had. So, guys, if you're going to have sex with a woman, you need to follow up and find out if there's a baby that results out of that, if you want that to be your child.
Dan, in all honesty, I have no idea how that becomes a factor. I would assume that you can counter that argument with perhaps evidence that you were not.
If I'd had known, I would have done something.
Right.
Mark Gatos, thank you for being with us.
Thank you, Dan. Appreciate being here.
Adoption is a complex, multifaceted undertaking. Thank you for being with us. On behalf of the LawWorks, I'm Dan Ringer. Good evening. On the LawWorks webpage at thelawworks.org, you'll find a listing of recent The LawWorks program topics and additional information about this show's topic. If you would like to recommend this program to a friend, you'll find a video of the program at the LawWorks website. You'll also find free video and podcasts of previous programs on YouTube and iTunes. If you would like to suggest a topic for a future program, or if you're a school teacher and would like to receive a free copy of this show for classroom use, send us an email to thelawworks@comcast.net.
The LawWorks is produced in cooperation with the West Virginia State Bar, the Mountain State Bar, and the West Virginia University College of Law. The LawWorks is made possible by the generous support of the West Virginia State Bar, the Monongalia County Bar Association, and by a major grant from the West Virginia Bar Foundation, promoting public knowledge of the law in West Virginia. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system.
From West Virginia Public Broadcasting.